Courtroom chaos. The judges blocked the subpoenas of Justin Baldoni's lawyer as Blake Lively files for sanctions. We got Ron Zambrano here to explain it all. Welcome to Popcorn Planet. I am Andy Signore. So excited to have Ron back on the show. Ron, how are you doing?
I'm doing good, Andy. Thanks for having me back.
Always appreciate you making time. I know you're a busy man. The audience loves it too. We love hearing from you. And you had a moment to go through some of the recent filings, not everything. Man, this case is insane. The amount of stuff each day that comes in and out. I want to get your thoughts, though, on the fact that the judge has now blocked Blake Lively's subpoenas of Justin Baldoni's legal team. I mean, this was expected. It's not pretty typical to be able to get stuff from the lawyer and his clients. That's privilege. But as you read this opinion and order from Judge Lyman, he basically admitted to saying, well, look, yes, you already admitted in open court that there is no agreement, so I'm going to allow them to ask for that, which I imagine they'll do with some sort of sworn affidavit. But beyond that, specific communications will not be handed over, correct? Was this the right verdict? And can you sort of explain to the audience what this all means?
Yeah, so the judge took a very tempered view and I think specific view as to what each individual request is asking for, splitting them into three categories. So the first one, he's like, okay, 1 through 4 have to do with things that the Liner firm or Friedman's office has with regards to representing content creators generally. And I guess in open court, somebody from the Liner firm said, listen, we represent content creators independent of this lawsuit, and we, those documents, one, have no relevance to this case and is also protected communications by themselves. Oh, and by the way, having to do with the content creators that Lively is concerned about, there are no documents; those don't exist. So he said that in open, or she said that in open court. So the judge says, okay, so then no harm, no foul, to the extent that I'll protect your content creators having nothing to do with the Lively case, but I'll so that's granted. I'll deny it with regards to the content creators Lively cares about because you're telling me those documents aren't there anyway, and we can move on. So that I think, again, it's a very, because that way the judge is taking the attorney's word for it, Liner's word for it, like there are no responsive documents, and the judge goes, okay, until you tell me they're lying, I have to take their word for it. Let's move on. I think that's very, very, astute way of doing it.
But then regarding specific communications and the other sort of requests for productions, that's where he said no.
Yeah. So in the other two, he said no. And again, he took a very, very specific category by category analysis. So for the second one, had to do with documents between like
communications and concerning content and media generally.
Media generally. And he said, listen, this is really overburdensome. This is and to the extent, like the timing of it, a lot of it had to do with the judge saying, listen, when you first started this and then you amended the complaint, there seems to be a disconnect. Now you can get, if this information exists, you could probably get it through another less intrusive means, less burdensome means. You can go through it there. I'm not telling you this isn't relevant. I'm not telling you, if you get it, you may not be able to use it in court. What I'm telling you is I'm not going to let you get it through this particular medium because it's very burdensome and it might violate certain privileges that exist. So again, he was very and that's why he's using this word without prejudice, because he's inviting, he says, if you have more to tell me, listen, we've tried everything under the sun to get this another way and it's not working, we need to come back, then if the judge is satisfied with those efforts that don't bring to fruition, then he will reconsider this, which I thought was very, very interesting.
What is, as someone who handles these things, you know how it works, you're a lawyer, you've dealt with the media, is he not allowed to talk to the media? Because that's what's really weird about all this, is that she's complaining that, and she's now asking for sanctions about all this too, as what's the next turn, as he's sort of denied this. It begs this whole question of well, is he allowed to go out and speak in defense of his client and put evidence out in the public, given that Blake Lively started all of this with a CRD complaint filled with evidence that's traditionally not in a CRD complaint. She kind of started this whole thing to begin with. So is it not okay for Friedman's team to be out there speaking to press or creators to say, here's our official statement, or here's the evidence that dropped that's part of our legal documents? Where is the line as to what's allowed and what's retaliation in your mind?
That's a great point. So under the litigation privilege that exists in every state, California, New York, things that anybody say connected to what's called a pending judicial proceeding like this is privileged under the litigation privilege from suing, because that would be a suppression of our ability to bring grievances to the courts, right? And you could sue over every lawsuit and all that stuff, and which what President Trump, or before he was president, used to do very well. So what is the line? The line is when you start getting into things that are absolutely not true, that are so far away from the lawsuit that a judge can say, this has nothing to do with the lawsuit. You're just talking trash about these people. You're not referencing the lawsuit. The lawsuit's been over, something like the lawsuit's been over, or you no longer work at that firm, something like that. Where there's really it's really hard to connect the dots between the lawsuit and the communication that someone else is upset about. Here, you're absolutely right. These things are 100% connected to, it's not it's very dark, stark, long, not very long, but line between dot of lawsuit and the communication or the press releases from Friedman. What they really want to see is if there's a secret communication between Friedman and a content creator going like, okay, now it's time to really be, terrible, use these words, and, kind of orchestrating the narrative versus just making comments. I think that's what they're trying to get to, but that is also, I believe, something that can be sought through another means, which is talking to the content creator. The content creator goes, yeah, because that person, the content creator, is not necessarily have the same protections as the attorney, but is also connected to the lawsuit. But if for some reason the content creator is forced to sit down for depo, which is an easier path, which the judge is saying, then the content creator can say yes or no, right? And look, you can go that way, but you're not going to get it this way. I think that's the balancing that the judge is saying.
But so just so we're clear, he's allowed to speak to the press about the case. That's because that's what's weirdly being, I feel like, spun in the narrative of Blake, is that any communication Wayfair parties, anybody, whatever them had with press sort of defending themselves with statements is somehow part of the retaliation campaign or ongoing smear campaign. And you're legal. That's not the case. They're allowed to defend themselves.
Yeah, they're allowed to defend themselves. They're allowed to make statements about defending themselves. That's absolutely above board. That's 100% above water. And you're right that the Blvd team is trying to frame this narrative like that they are somehow everything is open game to attack. Every single statement that's published is open to attack. I believe that is something that was trying to be addressed by Friedman's initial informal discovery letter. And I think a lot of people that are watching this, like you and me, are waiting for the judge to be like, to make a stern stance on that point. But I don't think the judge is going to do that until there's a more formal motion, like what's called the Rule 56 motion for summary judgment, where the privilege is affirmatively asserted. Like Blvd affirmatively asserted the privileges that led to the initial ruling of dismissing the complaint with leave to amend on certain instances, where the judge said, these are privileged communications the cross complaint's based on. And, we're not allowed to do that. That has not, I'm a little surprised that hasn't happened yet from the Friedman side with regards to that last cause of action regarding anything having to do with, the smear campaign. I'm surprised that hasn't really been, the same tactic hasn't gone the other way, because I think it's a really good motion. So I don't know. I don't know why that hasn't happened, because it pretty much falls on the same thing that Baldoni was trying to say about Blvd. The only difference is Baldoni didn't make a claim for sexual harassment.
Right.
Blvd did, so Blvd can make this other argument.
Now, about this sort of her trying to get sanctions, saying that Friedman's reportedly made improper out-of-court statements that they argue are designed to influence jurors. Is there any version of this that could be true, that he's now suddenly violating the order and immediately creating these inflammatory, biased sort of statements through his clients, going to people, Billy Bush, Meghan McKelly, suggesting to TMZ that Lively is afraid of the truth. They're doing this whole sort of rewritten thing of what's Friedman's goals. But what's interesting is in court, it seems they misquoted Friedman as saying that he called her the B word in one of his interviews when it was actually Megyn Kelly who said it. And another quote of calling her narcissist, it was actually Megyn Kelly, and he said, well, I'm not a doctor. A lot of the stuff he said actually wasn't quoted as bad as they seem to think. Isn't he have a right to sort of put this out there in that way? Or do you think there's a version that sanctions? And before I go there, I guess there's one issue I do want to address as well, in that they leaked the whole transcript, it seems, of the correspondence. And I had this question, and you told me beforehand, so spoiler alert, but tell the audience, that's not typical, right? If they had a section of the deposition to share, they should have just only shared that port where apparently the whole thing was then attached, which she called out and jumped on immediately. And you say that was a mistake on Friedman's side. They shouldn't have done that. So is there a part of this where they've gone too far? Could these sanctions be actually, given?
So it depends what the judge is going to cling on to, is what is the conduct that's violating, what we call violative conduct that empowers the judge to sanction anybody, right? The judge can sanction people, but it has to be within these confines and standards that are already established. So with regards to, what he may or may not have said out of court, the judge is going to sanction him because it has nothing to do with the litigation of the lawsuit. The judge will say, listen, if you're upset about what he's saying in court, then maybe you want to amend the complaint, and see if you can get him there. But he's not a defendant, he's not a defendant. He's not saying everything you're saying he's saying. So with those types of things, I think the judge is going to roll his eyes and be upset. He's probably upset already anyway. The transcript being attached and then filed for everybody to see, after it's been acknowledged by the judge is aware that.
It was redacted, but even still.
Yeah, it's bad. It's really bad form. I think it's playing too loose, even though you're trying to redact things. I can't imagine how many hundreds of pages it was, but if you probably only need at the most 20 for purposes of your whatever it is you're seeking that you're attaching it for. I really think that probably will be seen as being fast and loose. I don't know what the sanction would be for that. It will be a monetary sanction, but it's one of those things where the judge, I think, fairly can say, listen, man, yeah, technically people can read everything, but we all know the subtext of what you're trying to do and the court of public opinion, and it may not have swayed, but I need to kind of rein everybody in and make an example of Friedman with, a sanction that's probably to him not that big of a deal, but it might be $4,000 or $5,000. And that'll be something that maybe will both parties be like, okay, maybe we have to rein in what's going on as far as what's being filed.
Judging by how much they've billed already, I don't know, man.
Well, $4,000
seems like it's an endless amount of money.
Yeah, I don't think because the thing is, the judge is going to start off small, because the second one won't be the same one. He may be open to what's called evidentiary sanctions or issue sanctions, depending on the topic that's being done. You don't want to piss off the judge on the same topic more than once, right?
Right.
The judge is going to be like, you messed up. Here's a fine. It's not a lot for you, but I want to let you know if you do it again, it's not going to be a fine. It's going to be something that's going to affect your client's rights because you're messing up. And
ultimately, given all things we've heard and then potential sanctions, who do you, final thought, who's angering the judge more at this point, do you think? Where is he leaning, in your opinion, based on the mess of the docket it's become, the back and forth that we've seen? Who's winning today?
I think this is the second time Friedman's messed up. I don't know if you probably remember better than I, but there was a letter that was struck from the record that he spilled the tea
about Taylor Swift's. Yeah.
Remember that? So I think for whatever Friedman Baldoni, I do think Friedman is he should be counting the cat's lives at this point. He should be very, very careful. And I would not have done what he did, especially when the judge already basically reprimanded him, like, you know what you're doing. I'm striking this from the record. Be careful. And I don't think he was careful when he attached the entire transcript. I think that maybe he's got so much money, so much backing, it doesn't matter. But like, the judge can go beyond money and really prejudice Baldoni if the judge is pissed off enough. And there's been like 10 or 15 filings in the last 3 days. Like, the judge may be reaching that point. I don't know.
But he still blocked it and didn't let those subpoenas get to his team. So a win and a loss in a way today, it seems. But more of a win, I would imagine. No, but because this is a clear no-brainer, right? Did you ever think that they were going to be able to get him to actually be subpoenaed, Brian Freeman, to give up his clients? That would be totally against the law, would it not?
It would have been. Well, it was not allowed, right? And he didn't allow it. The thing is that yes, it's a win, but but Lively's, as far as we've seen, is playing at least post a lot of the stuff within the rules in the litigation, right? Whereas Friedman's team, he put in that letter stuff that the judge said you shouldn't do that. Now he put this thing, like, he's not really playing within the norms, and the judge already told him, like, this isn't normal. You shouldn't do that. I'm striking it. Be careful. And now he did a second thing. That's why I think, yes, it's a win, but it's within the rules. And the judge is going to not be biased because one person's more pissier than the others. He is so far taking one thing at a time in a vacuum, which is the way judges are supposed to be. That is a sign of a good judge. But I'm concerned about this. I'm concerned for Friedman if unless he fixes it first, like, oh, that was an accident, we'll refile it, and then we'll oops. The entire transcript fully redacted, because you could pick up on a lot, right? Like, wow, look at all the stuff and all the other things that were leaked with regards to who was in the room, who was where and what was saying what, and that Baldoni was there.
Well, Blake's team's using that too. Like, oh, look, Freeman already leaked all this information out, but I'm like, well, who's to say she didn't leak it out, and now using that to her benefit to make him look bad? I imagine that kind of stuff happens all the time, right? Where the team leaks something, try to making the other team look bad.
Yes, and I wouldn't be surprised if that happened, but it's not. But she didn't tell him to file the whole transcript either, right? So it does not help. It does not help. I don't know. I feel like this is one of the ones where Friedman didn't read the room. Could be wrong. He's a very successful guy, but
no, I saw it too. I'm like, wait a second, you attached the whole thing? That seemed like well, there you go.
It takes more work to redact the whole thing than just to pick up the pages you need. Like,
it seemed like, if that's true, which I get Blake's accusing, Blake has not always been honest in her claims. She said, I did criminal behavior and I didn't. So I guess we have to take that with a grain of salt, to be fair too. But always appreciate your insight. Always very neutral. Guys, also make sure you sign up over the website, popcornplanet.com, because you'll get first access to the documentary, which Ron is in. So hit up sign up right there. Pick a tier. Everyone, I think, doesn't even understand. Click one of these. You got to click one of these to actually become a level member, and you'll help us tremendously. So check that out at popcornplanet.com. Also, make sure you hit the subscribe button, hit the bell for all alerts, smash that thumbs up as well, and stay tuned. Hit the comments and stay tuned. We'll be live later today around 4, a little after 4 p.m. So join us live as we have a lot more updates, including news about my Google subpoena. What? You're not going to miss it. Thank you, Ron.
Thank you, guys.